Hi, I'm Jerry Sparks, President of AG Financial Insurance, and welcome to Risk Management Live. Today we have with us Rich Hammar, General Counsel of the Assemblies of God, and we're going to talk about workplace privacy, and really we're going to talk about how this happens in respect to computers and a recent phone call you had. So why don't you tell us a little bit about that phone call?
Jerry, a church contacted me last week. They had a situation arise. They wanted my counsel. The youth pastor of the church went in to meet with the lead pastor. And as he was talking to him, the lead pastor had his laptop computer out. It was actually a church-provided laptop computer. And the angle of it was in such a way that the youth pastor could actually partially see the screen. And he noted what he thought was child pornography. He didn't act disturbed. He just acted matter of fact. And the conversation ended. Well, the lead pastor had to leave the church later that day for a meeting, and the youth pastor just happened to be walking by his office, and he saw the laptop still sitting there on his desk. So he went in, he opened it, and he examined it, and he found loads of child pornography on that computer. And so this case raises the question of what, if anything, can the church do with that information that was on the computer, albeit church-owned, but was used by the lead pastor? Was that somehow an invasion of his privacy? And over the years, Jerry, I've received many calls, many emails on this very question of what right does a church have to inspect employees' workspace, which may include, not always, a computer, cell phone, etc. And that's the issue today. And as I told that church a few weeks ago, I think the backdrop for this question is a Supreme Court ruling back in 2010 called the Quan case, that's Q-U-O-N, which arose in California. The Supreme Court directly addressed the question of workplace privacy. And it's interesting, they reached a couple of conclusions. Number one, the court emphatically said that employees, in fact, do have a legitimate expectation of privacy in their workplace. And that extends to computers, even though they're owned by the employer. Number two, that expectation of privacy can be overcome in a couple of ways. The first of which is consent by the employee to inspection of his or her employer-provided computer. And consent, the court said, can come about in two ways. Number one, express consent, where the employee actually agrees to a computer policy that permits inspection of computers. And secondly, implied consent, where you don't formally give consent, but the court used the example of an employer that has an IT professional that is constantly accessing computers at the employer's premises and to update, to maintain, et cetera. And when you know your computer is subject to that kind of inspection, there's kind of an implied, a tacit admission that the employer has the right, and that negates the concept of privacy.
Rich, should a church have a written computer policy then, and can you explain what it should contain in it?
Yes, so I think the takeaway from the Quan case was employers, including churches, should have a computer policy that does a number of things, because the policy, according to the court, if it's drafted properly, can constitute consent to the inspection of an employee's computer by the employer. And so some of the key points, and the court mentioned several of these, that should go into a policy would include such things as emphasize that the policy only covers employer-owned and provided computers. It doesn't apply to an employee's own personal computer, laptop that he brings from home. It should clearly describe what is permissible and what is impermissible use of the computer at work. It should describe the potential consequences of inappropriate use of that computer. It should clearly authorize, and this is probably the most important component, it should clearly authorize the employer or its agents to inspect the employee's computer at any time, with or without reason, with or without justification. The fact is, there are many reasons why an employer would want to have the right to inspect an employee's computer owned by the church. And those include, sometimes you have to access information when the employee is not present it's on vacation or sick or whatever, and there's essential information you need to get, you need to be able to access that computer. You need to make sure copyright laws are followed. You need to upgrade computer software. There's just a number of legitimate reasons that should be listed as to why that computer should be subject to inspection. You want to determine whether use of the internet is not unreasonable. You need to determine whether the computer is being used for impermissible, unauthorized purposes. So there's a number of reasons why you would want to reserve the right to inspect computers. They should be listed in the computer policy. The computer policy should be explained to all new employees at the time they're hired. They should be given a form that they sign that in consideration of their employment, they agree to be bound by the computer policy and any other policies. A lot of times churches just say, all the policies in our employee manual or handbook, if you have such a thing. And I would say, and any future modifications there too. That's very important. So those are some of the things that should be in the computer policy. It should emphatically declare that the employer, the church, is the owner of the computer and all data stored thereon. So if you have this kind of written computer policy, Jerry, that's approved by the employee, consented to by the employee, according to the Supreme Court in the Kwan case, that constitutes express consent to the employer's inspection of those workplace computers. By the way, that happened in the Kwan case. The employee whose computer was inspected did give consent, but there was some question as to the validity of that consent. So you want to be sure there's an appropriate form that's signed that makes these declarations that we've just mentioned. So then the court went on to say, besides consent, there's a second way or reason or justification for employer searches of employees' computers. And that's if the employer has a legitimate work-related reason to search an employee's computer, and the search is reasonable in light of that purpose. So let me mention that again. It's kind of a twofold test. The employer has a legitimate work-related reason to search a computer that it owns, that's used by an employee, and the search is reasonable in light of that purpose. So if you satisfy that two-pronged test, that's, the court said, another justification for an employer to inspect its equipment.
What about state and federal privacy laws?
There are numerous state and federal privacy laws that apply to computer technology, such as the Electronic Communication Storage Act. There have been a number of cases where employees have sued under these laws, claiming that the employer's inspection of their workplace, including computer, cell phone, et cetera, constituted a violation of these laws. A couple of these cases have involved churches, and it's interesting, in each case, the church inspected an employee's computer, a pastor's computer, because of allegation of inappropriate material, child pornography in one case, just regular pornography in the other. And one court concluded that the Electronic Communication Storage Act, this federal law, was violated by the church. In the other case, it concluded that it was not, because the employee had consented to the search as part of the computer policy acceptance at the point of hire. So these are laws that are very complex. They're continually being interpreted by the courts, expanded, I would say, as well. And so it's very critical for any church, before you take adverse employment action against an employee because of what you find on that person's computer, make sure that you have legal counsel that your search did not violate this particular statute or other state and federal laws. Also, you have invasion of privacy, which is another, it's not a computer inspection type of law, it's just a generic law that you cannot invade somebody's privacy. There are various ways you can do that, but some courts have addressed this in the non-church context. No church case has addressed this yet. And some courts have said that, yes, it can be an invasion of privacy under some circumstances for an employer to inspect an employee's computer. Kind of overarching everything that we've just said is another very important factor, and that's the ministerial exception, which is it's a doctrine that was adopted by the U.S. Supreme Court in a 2012 case by unanimous vote, 9-0 of the U.S. Supreme Court. concluding that the First Amendment guarantee of religious freedom prohibits the civil courts from resolving employer disputes with their employees. So an employee cannot sue an employer, if that employee is a minister, for some dispute, discrimination, wrongful discharge, et cetera. Because for a court to get involved in these cases, it would have to make determinations as to the fitness of a person for ministerial status. That's something the First Amendment prohibits. So what is the reach, the extent, the contours of this doctrine? It's constantly being applied in other contexts, such as compensation, Fair Labor Standards Act, et cetera. And one of those two cases I mentioned, involving churches a few minutes ago, did bring this up and said that the ministerial exception would bar any liability under these state and federal computer privacy laws with regard to church inspections of employee computers. So if the employee is a minister that is being compensated for ministerial and was hired for ministerial services, it's possible that the ministerial exception would bar any electronic privacy claim by that minister against the church. One court reached that conclusion, one court did not. So, but again, it's imperative that you have legal counsel guiding you, someone who is familiar with these laws and their application in your jurisdiction.
So what if an employee has his own iPad that he brings to work and he has his email on his iPad, uses his iPad for work, but it is his own personal iPad or his own personal computer, so it isn't a company computer, but there's inappropriate information on that and it is found out?
The employee's expectation of privacy is increased substantially under those circumstances. Everything we've talked about up to now, Jerry, deals with the expectation of privacy of an employee in a church-owned computer or cell phone or whatever the instrument may be. But the expectation of privacy, even the court recognized it under those circumstances, but it's even much higher if it's an employee-owned computer, phone, or whatever the device may be. So you need to be very careful in inspecting. In fact, I would not touch an employee-owned device like these without legal counsel.
Okay. So tell us what the outcome of this case ended up being. What was your advice to him?
The youth pastor shared this information with a business administrator that the church had. And that's the person I communicated with. And the interesting thing about this case was it involved child pornography. Under federal law, if you're guilty of possession of child pornography, it's a mandatory 5-year sentence in a federal penitentiary. There's no parole or early out in the federal system. I said you need to be very careful who possesses that computer. And my advice to them was they need to contact the authorities. That crime is so severe, it's so serious. And for you to know that information and ignore it exposes the church to significant liability. You know, studies have shown, including the FBI profile, that if there is any smoking gun, if there is anything that suggests that somebody is a pedophile, it's very difficult to do that. They're frequently missed. But the one thing that is associated, as you would expect, is child pornography. So you potentially have a pedophile here, and according to that FBI profile, they're promiscuous, they're predatory, they have the highest recidivism rate, and they're incurable. So it's very likely that children have or will be molested, and for you to be sitting on that information and doing nothing with it, that's a very precarious position.
Wow, what a great subject to cover today, and a hard subject, but I know that it'll reach to our churches and to people that find this information. So I appreciate your time in discussing this and bringing the Quan case to us so everybody can know and understand where their right to privacy starts and where it ends. So we want to thank you for joining Risk Management Live. Thank you, Rich, for doing the research on this, and join us next time for Risk Management Live. Thank you.